This is immigration attorney Parviz Malakouti, and about 2 weeks ago, I got a call from a gentleman who had a green card. He had a conviction from several years ago, and he wanted to apply for naturalization. He called me to ask whether I think he qualifies for naturalization. And in that conversation, he brought up the term crime involving moral turpitude, okay? He wanted to know whether his conviction was a crime of moral turpitude, and he thought that if it's not, that means he's all clear to go. He can apply for naturalization. And we did, of course, speak about whether his conviction was a crime involving moral turpitude, but I had to break the news to him that the analysis for whether you qualify for naturalization and whether you are subject to grounds of removal, aka deportation, does not end with just finding out if that crime is a crime involving moral turpitude. The analysis is much deeper and it has several other factors. So first of all, I'm talking about removability, which is in the Immigration and Nationality Act, Section 237A. Section 237A lists all the different grounds that can make somebody that's within the United States subject to removal, aka deportable, okay? Listed in those grounds is anybody who's been convicted of a crime involving moral turpitude, okay? But that's not the end of the story. If you've been convicted of a crime and you have a green card, you have to also figure out whether that crime qualifies as what's called an aggravated felony, okay? Aggravated felony. And if your crime was a misdemeanor in your state, for example, let's say it's a California misdemeanor, that doesn't mean necessarily that it's not an aggravated felony. The analysis for determining whether a conviction is an aggravated felony also is an in-depth analysis that usually has to be completed by an experienced practitioner, a crimmigration practitioner, as we said, which is basically somebody who practices at the intersection of immigration law and criminal law, okay? So first and foremost, if you have a green card, you need to find out whether the crime is a crime involving moral turpitude. Secondly, is it an aggravated felony under the INA? Then after that, it has to be screened for different types of crimes which are named specifically as crimes that would make somebody removable. Some examples are, for example, crimes involving domestic violence or crimes involving violence against children, okay? Another example is firearm offenses. I had to look down at my sheet for a moment. These are examples of crimes that are named specifically in that subsection as crimes that make somebody removable, okay? So if you're in the position where you have a green card, you have a conviction, and you want to find out whether you can qualify for naturalization, first thing is you need to find out whether you're removable, okay? You got to play defense before you try to play offense. Make sure that you don't get the green card taken away when you try to apply for naturalization. Okay, so these topics get very complicated very quickly. I hope this helps a little bit. The last advice I want to leave you with is that if you are in this position, at very least, you need a consultation with a qualified immigration attorney, and you may need to actually be represented by the attorney as well. But at very least, get on the phone with an immigration attorney, qualified immigration attorney, to speak about the specifics of your situation so that you don't run into trouble rushing an application for naturalization that puts you at risk of being put into removal proceedings and having your green card taken away, okay? That's it. Right now, today, it is June 27, 2020. We are in the midst of our COVID pandemic. Stay safe out there and have a great day.